Good afternoon, Chair Dan Lanningham, members of the Commission. I'm Ed Sullivan. I represent Sage Helvetia. Thank you for allowing us to give this brief presentation to our case.
So, is your microphone on?
It is now.
Now it is. I think you all heard me. I hope you did. I'm going to start the presentation, and we have three members of our group to supplement that. My presentation will focus on two principal points. The first is the point of balancing and what the obligation is in balancing. We believe that the reserve statutes and rules require that the decision be both internally consistent within the overall land use framework, as well as consistently applying the factors across the region. The second point I'll talk about is the role of the reserve factors. We believe, in short, that these factors are more than just considerations, but require analysis based on the record and the application of substantial reason. That obligation is not discharged if the factors merely travel through the heads of the decision makers in a nanosecond. Indeed, the role of substantial evidence is meaningless unless the application and balancing of those factors is explained in a reasoned decision. That consistency and coherence, we believe, is missing in the decision before you today. The first point relates to the obligation to balance a multiple stated series of objectives that the factors must lead you towards. You could probably all recite with me the mantra of the balancing requirement that deals with a set of urban and rural reserves that in its entirety best achieves livable communities and the viability and vitality of agricultural and forest industries and other matters. We believe that for a balance to occur, that urban livability cannot always trump agricultural objectives, certainly not in the event where those lands meet both urban and rural factors, as is the case in Helvetia, Area 8B in Washington County. And that was certainly not the approach taken by the other counties and by Metro in the previous iteration of this order. And as for high-value farmland proposed for urban reserves, these foundation lands must be protected, in our view, to the same degree as they would be protected in the event of an urban growth boundary expansion, or in the application of goals 3 and 14, the priority statute, and our state land, agricultural land statute 215, 243. Nothing in the urban reserves statutes or rules evidences any intent to throw out the priority system protecting foundation farmlands, merely because urban reserves are involved. The recent McMinnville case may be instructive as to how a court would likely read the requirements of combining goals 3 and 14, the priority statute, in consideration of the factors for urban and rural reserves. And that case says that the priority scheme prohibits elevating lower priority lands for urban designation based on, for example, the cost of providing services. The court also rejected designating additional lands, such as reserving higher priority or lower quality or conflicted lands, as undesignated, but designating lower quality lands for urban use. Let me move to what I think are a series of inconsistencies in the Washington County presentation to you. It illustrates the absence, in our view, of a coherent balancing process in this proposal. For balance to have meaning, the factors must be applied consistently throughout the region, and any deviation have to be explained by way of findings. In this case, unexplained inconsistencies abound. For example, US 26 became the hard boundary in Clackamas County, but was disregarded entirely when it came to designating Area 8B for urban reserves. Under OAR 616-27060, lands that are potentially subject to urbanization during the planning period are suitable for urban reserves. Clackamas County responded in those cases in which foundation farmland was threatened by urbanization by designating those lands as rural reserves. Where urbanization threatened foundation lands in Washington County, such as in Helvetia, they were designated as urban reserves. The counties also took different approaches when it came to evaluating the quality of farmland. Clackamas and Multnomah County relied on the ODA report, whereas Washington County found reasons to disqualify foundation farmland from agricultural protection by rural reserves, including by looking at whether the land had irrigation rights. Now, irrigation rights or water availability can be used, but only if there's a showing, if they're needed. There's no showing in this record that it was needed. Secondly, parcelization and dwelling density patterns analysis, in this case, was based on a 7,000-acre sub-area in the case of Helvetia. The illustration indicates that the parcelization pattern to the northeast of Area 8B is much greater than that in 8B itself, which is now proposed for urban reserve designation. And by failing to make any findings of fact, acknowledging that 8B contains one of the few last concentrations of Class 1 soils in Washington County, as Mr. Meckler will discuss. The second issue that I want to make sure the Commission turns its attention to is the role of factors. The county, Metro, and the DLCD report before you continually reiterate that the reserve factors are mere considerations, and therefore LCDC and a court will only require some evidence to support an overall conclusion of compliance. We don't agree. As I said, these factors are more than simply considerations that rush through the heads of decision makers. The fact that there were lengthy meetings to discuss these things, the fact that there was horse trading among parcels, does not equate to a reasoned process. Where the factors exist, adequate findings require an identification of the purposes to be achieved by the application of the factors, along with an explanation of how each factor was applied to achieve that purpose, has long been a part of Oregon's administrative law since the Sunray Dairy case in 1975. Indeed, having the greater discretion in the application of factors puts a corresponding greater duty on the Commission to explain how these factors were applied and balanced. Even in the land use context, courts require more than just evidence that the factors were considered. You only need to look at the Woodburn case involving the periodic review order, where the court said that LCDC must demonstrate in its decision the reasoning that leads the agency from the facts it has found to the conclusion it draws. And in Metro's previous iteration of urban reserves, 1,000 Friends versus Metro in 2001, the Court of Appeals said substantial evidence requires findings not only explaining the quality of the land chosen, as well as findings justifying the selection of some lands over others. The findings in this case lack this substantial reason when they fail, for example, to explain how Area 8B, as part of the largest remaining block of Class 1 soils in the county, qualifies for urban reserves designation. When those findings rely on an application of an urban reserve factors to a 7,800 acre pre-qualification concept plan to justify extending services and utilities to 8B, which only has 440 acres. When they fail to explain why the other 9 sites identified as appropriate for large lot industrial use, assuming that you consider specific uses at this stage of the process, which I don't think you can, are not more suitable given the soil quality and the foundation land status of 8B. When those findings fail to explain why detailed large lot industrial land need determinations are made and are found acceptable, and yet factors requiring mitigation of impacts, buffering, etc., can be vague, need not be in place, nor guaranteed to occur. When those findings rely on high dwelling density, slightly smaller parcel size, and water availability, other than when necessary, in evaluating long-term agricultural sustainability, when these are not mentioned as part of the factors. When they fail to explain why trading lands in Cornelius for Helvetia will affect the region as a whole. And finally, when they fail to analyze the qualitative impacts from urbanizing Helvetia rather than Cornelius, and how these impacts will alter overall livability in the region. Our conclusion is that there's an obligation to protect farmland, and that must be read into the application of the factors before you in making this decision. That the reserve factors were not, but should be, applied uniformly throughout the region, and any inconsistencies explained by way of findings. And finally, that urban and rural factors must be analyzed and explained within the framework of the objections. Mere consideration is not enough. We urge the Commission to take the time to make a reasoned decision. You have an awful lot before you. You have an awful lot of parties that want to advance their interests. We understand and respect that. But the notion that you need to make a decision right away may get you into the same trouble that has occurred before. We ask you to take the time. We appreciate you listening to us, and look forward to your deliberations. Thank you.
Next.